In today's video, I want to share with you the absolute, positively most important document that you must have for your online business. You want to know about it? Let's do this. Hi, my name is Jim Hart. I'm the founding attorney here at Hawthorn Law, where we help you, the online business owner, to get your legal house in order so that you can focus on what you do best, and that is build something that truly matters in the world. Today, we're going to be talking to you about the number one most important document that you need for your online business. Anyone who sells a product or service online, you probably want to make sure that you're legally protected, that you can get paid at the end of the day, and that you're not going to have any issues if something comes up with clients that you're dealing with. Am I right? And for most of you, the one thing that stands in the way of making sure that you're not going to have any problems if a disagreement comes up is the fact that you do not have a legally enforceable contract in place for your business. This is the number one most important document that you need. The reason why this is so important is because when you do not have a contract in place, something that you can go to, that you can use whenever you're working with a client or a vendor or an employee or someone like that, you are putting yourself at risk of not getting paid, of having your intellectual property stolen, of not being taken seriously by other people that might want to work with you, and of not being able to enforce your legal rights if and when something goes wrong with the contract, which I hate to say it, but a lot of times does happen. Let's look at this from the example of an attorney, for example. If you wanted to come to me and hire me to do legal work for you, and I said, okay, well, I don't have a contract for that, but let me write something up and then I'll send you a contract because I didn't have one, that makes me look unprofessional. And frankly, that's not the case. I do have contracts. But if I did not have that contract, then that makes me look like I don't actually know what I'm doing. Does that make sense? So it's the same way for you. If you go to work with somebody, a client, a consultant, like I said, an employee, anyone like that, and you do not have a contract already in place that you can go to and use, it's going to make you look like you don't know what you're doing. So in today's video, I want to share with you how exactly you write a contract that is going to work for your business and the 5 clauses that you need to have in every single contract, no matter if it's an employment contract, a contract with a client they're going to be working with, or a contract with a vendor that you're going to be buying something from. It doesn't matter who you're using. You need to have these 5 clauses in place in your contract, and I want to share with you exactly how you're going to craft them so that you can use them in your business and you can have a workable contract that will protect you and that will keep you from getting in legal hot water if and when something goes wrong. So the very first thing you need to have in your contract is you need to have payment terms and a delivery schedule. And these things kind of go hand in hand. Some people break them off and say they're 2 separate things. I like to have them as one clause in and of itself. And the reason for that is when I do my contracts, I typically break my legal representation contracts into stages. And I will have a different fee that is due at every stage of the engagement. So I bill flat fees. A lot of lawyers do hourly. You might do hourly for some of the work that you do with clients. And that's okay. That's perfectly fine. But I do like to break my contract down into stages. You know, depending on the type of business that you're in, you might have 2, 3, 4, 5 different stages, and there may be a different fee due at each point of time that you're dealing with those stages. So you need to make sure in your contract it is crystal clear exactly how much you're getting paid, when you're getting paid, and what the deliverable is that you're going to be giving to the client at the time that you hit that stage of the contract. Does that make sense? Everybody is going to have a different structure to the way their business works and a different process for how their business flows. If let's say you're a strictly online business and you have a course, there might be one fee due when the person signs up for the course, and maybe that's a flat fee and it's all due up front, and that's fine. That might be the way you do it. Maybe some people do it into payment plans, and so you will want to have the payment plan written in your agreement. And this would be a little bit different agreement because it's not necessarily a one-to-one client contract, which is going to be much more specific to the client than if you're doing a course, and it's going to be one contract that's going to work for everybody that does that course with you. Number 2 is going to be the refund policy. It's really important that you have a good refund policy that dictates how and when somebody would be owed a refund if you're working with them. And this is especially important if you're doing online courses, because a lot of times the materials you submit in the courses are available on demand at the very beginning. You don't really want somebody signing up for your course, paying the fee, getting access to all the materials, trying to steal those materials, theoretically. Hopefully people don't do that, but we all know human nature, people do. Then they want a refund. Well, you may have a very strict refund period, whether it's, a week, 30 days, 60 days, whatever it might be. You want to make sure that you've outlined what the refund period is going to be for your course or for the client work that you do or for whatever it is that you're doing. And you want to make sure that's clear in your contract. The third clause that you really want to pay a lot of attention to is jurisdiction. And what I mean by this is jurisdiction is a really fancy term that means where you can bring a lawsuit. If somebody enters into a contract with me, we're going to have a jurisdictional clause that's going to say that if they want to sue me or if I want to sue them over the terms of that contract, it's going to happen where I live in Wake County, North Carolina. I don't want to go travel into, Georgia or Montana or California or Ohio or anywhere like that. I don't want to go anywhere else. If somebody wants to sue me and they want to come to court, you got to play on my ball field. And I have that in all my contracts. And for you, you need to make sure all your contracts dictate where you want somebody to bring a lawsuit if there is a disagreement between you and the other party. And so you really want to fight for that jurisdictional clause in there that says that it's going to happen in your backyard. And that's important for a number of reasons. If you are in, Florida and you're working with somebody in Alaska and they want to sue you and they decide to sue you in Alaska courts because you don't have this in your contract, or maybe they decide to slip in that they can sue you in Alaska. Now all of a sudden you got to go to Alaska, hire a lawyer up there, maybe travel there, all sorts of things just because you put a clause in the contract that allows them to sue you in Alaska. You don't want that. So you need to make sure that you've got a jurisdictional clause in your contract that dictates where a lawsuit would happen if there is a disagreement between the parties and you do need to sue somebody over the enforcement of the contract. All right, number 4 is who owns what. And this is really important, especially when we're dealing with creatives out there who make videos, photographs, copywriters, anyone who's drafting something that's a creative work that might have copyright attached to it. You want to make sure it's clear in the contract who that work will belong to at the end of the day. The way this works is the copyright law in the United States says that the person that creates the work is the one that owns the copyright to it. A good example of this would be a wedding photographer who takes pictures at a wedding. Then they own those pictures. Even though they're your pictures, you're the one that's in the pictures, the wedding photographer is the one that owns all those pictures until you've paid all the fees. You want to make sure that if you're the person that's hiring the wedding photographer, you want to have a work for hire clause in the agreement that basically says that you own the property, the intellectual property to what they're creating. Now, frankly, if you're a wedding photographer and you're listening to this, chances are your contract is going to not want to have a work for hire in there because you are going to want to own the intellectual property of those pictures until you get paid in full. And if you don't get paid in full, then you might give away, smaller images of the pictures, maybe ones that have a draft on them or have your logo plastered across the front as a watermark so nobody can copy those pictures. And there's all sorts of different things you can do to protect your intellectual property, which you want to make sure you do, especially if you are a creative, to make sure that you do not include a work for hire in there and that make sure that you own the copyright until such time as you get paid. Now, again, if you're the one hiring somebody to do work for you and you're the one creating the contract, then you want to make sure you put a work for hire in there. And I have seen this where I've had clients in the past who hired a friend to do some photography for them for product images for an Amazon listing. He hired me to do the copyrights for him, and we had to do a number of copyrights and a bunch of different bundles and things like that. Because the friend was the one that took the pictures, we needed a contract in place that basically said work for hire. This person was doing the work for my client and gave up the rights to all that intellectual property. That's really important to have in your contract, especially if you're doing any type of creative work. All right, number 5, the last thing that you need to have in your contract is a termination clause. And this is a clause that's going to basically say when you can terminate the contract, when the client can terminate the contract, under what terms that would happen. And does there need to be a notice provision? This is especially important if you are, let's say, for example, a web designer who charges a monthly retainer to work on a website. Maybe if somebody wants to fire you, they have to give you 2 months notice before they can do it, or 3 months notice. Or maybe it's an annual contract, or maybe it's month to month, whatever it is. You want to make sure there's a clause in there that dictates when the contract can be terminated. And at the same time, let's say you're doing this work in stages, that makes it really easy, because if you've done the first stage of the project, can you get out of it at that point? Like, let's say the client wants you to finish the project. Are you allowed to get out? Are you still obligated to move forward to stage 2 if the client pays you for that? Or can you say, you know what, I've dealt with you with the stage 1 and you were kind of a pain and I don't want to deal with you anymore. I want to get out of this contract. Make sure that you have that termination provision in there that dictates how and when you can get out of the contract if you would like to do that. So the big question that you have to ask yourself, and when you're thinking about all these terms that you're going to put in your contract, is what difference is this going to make in your life when you do have this contract? And I submit to you that you're going to be able to sleep better, that you're going to be able to rest easier, and it's going to have a profound impact on your business, because now all of a sudden you're not going to be looked at as this kind of run-of-the-mill type of contractor or photographer or designer who doesn't really have their you-know-what together, but you're going to be looked upon as someone who really is a professional, who knows what they're doing. They've got their contracts in place. They're a force to be reckoned with. People are going to take you seriously, and in all honesty, you probably will be able to collect higher fees, and you're going to have a better chance getting those fees paid if and when you have a contract in place that's professional looking, that's well written, that details exactly what you need to have happen in your business when you're working with a client or a vendor or, like I said, an employee, consultant, whoever. So if you like what I'm talking about here, make sure check out this audio video right here. I am putting together a playlist with all of these videos related to contracts, trademarks, things like that. Check that out. We'll see you next time. Take care, folks.